The uproar over the government's surveillance order has not even died down, and there is another controversy brewing. The Indian Express has reported that the government is mulling an amendment to Section 79 of the IT Act, which would make it mandatory for online platforms to track unlawful content online. Now, this would include breaking the end-to-end encryption that platforms like WhatsApp provide. And this report comes just days after the government gave 10 agencies the power to look at activity in any computer in India. Now, privacy and free speech activists are clearly alarmed. What are their concerns, and are they valid in the face of national security threats and a need to end social media-fueled mob violence? To speak on all this and more, I'm joined today by Amit, who is the national head of the IT cell of the Bharatiya Janata Party. Apar Gupta is joining us, who is executive director of the Internet Freedom Foundation, and Nikhil Pahwa, the founder of Medianama, joins us as well on the show. Welcome to all of you, and thank you for speaking with us here at Bloomberg Quint. Amit, I'd give you the first chance to explain what's going on, because these are two, news stories which have emerged in just a matter of days, and seen together, it seems like the government is very keen to find out what Indian citizens are writing on their Facebook pages, or sending in their WhatsApp messages, or tweeting out. Is the Indian government trying to snoop on all of us?
Well, not at all, Tamanna. Let's understand the first amendment that got talked about so much. There was a law brought in 2009 which laid down supposedly safeguards for encrypting or intercepting and decrypting information, but it did not specify the agencies who could do it. What the NDA has essentially done is specify 10 agencies who could do it, therefore limiting or restricting the unlawful or the illegal use of this act. There's an RTI of 2013 which very clearly says that about 9,000 calls and about 500 emails were being regularly intercepted and decrypted under the UPA regime, and no one knew who was authorizing it. At least now, with the notification that has come in, we know which are the agencies which can do it and the authorized person who can approve of anything like this. So it in effect ensures that there is some procedure and it is followed as per law. Now, coming to the amendment in Section 79 that you just spoke about, there has been a lot of talk, particularly from technology evangelists and so-called privacy right activists, about the menace of fake news, about the menace of the social media growing out of proportion, particularly when it involves national security, ethnic violence, race-related violence, caste-related violence, and so on and so forth. What the government is essentially evaluating at the moment, and it's not something that it has gone ahead and done with, but it's evaluating what it could do along with various social media platforms which are there, whether it is Facebook, whether it is Twitter, WhatsApp, and the others, and ensure how people's and innocent people's lives is not put in danger. A small example, we all know of the exodus that we had of the northeastern people from Bangalore, particularly fueled by a rumor. And there have been several such news where people have been caught and they have been, beaten by people on the pretext or on the fear of child lifting. Yeah. These news have been coming out quite regularly, and the common theme has been that it has been fueled by rumor which was amplified via social media, via WhatsApp. Now, you have to strike a fine balance between privacy and ensuring that policing, or for that matter national security, is taken to a level where technology is a facilitator and not a hindrance. And that's exactly what the government is trying to do. I think the privacy and rights activists have to perhaps look at what the details are before they sort of jump the gun.
No, so I've got on the other side Apar Gupta and Nikhil Pahwa, and if there are any two privacy activists who would look at details, it's definitely both of them, and I'm sure they have in this case. So there are two things. You're saying as far as surveillance is concerned, it was done before. You're just putting it in a more clear and transparent manner where you know who is doing the surveillance. And as far as amendments to Section 79 are concerned, you're saying we need to do that so that we know who is spreading all of these malicious rumors which have led to people being lynched and killed. Apar, your response to both of these points, because at some point you do have to balance people's privacy with the task of running a country.
It goes beyond dispute that terrorism needs to be contained and prevented, and the safety and security of persons and national interest counts for a very important consideration. This is not what either the MHA notification, which activates wide surveillance powers which were inoperative and are in addition to the telegraph rules, do, and secondly is the proposal to change the intermediaries guidelines, which was being done secretly and after the Indian Express story has now been opened up to public consultation. I will first go on the MHA notification and how does it change, what does it change, what is different from the RTI which has been referred to by Mr. Malviya. The RTI which has been referred relates to interception and disclosure of data of the number of requests for phone calls, emails, and was done earlier under the telegraph rules. The rules in 2009 which were made under the IT Act, and then they were in effect legally inoperative till the notification was issued by the MHA. So in a sense, the 2009 rules got activated only with the MHA notification. So what are the additional powers under the 2009 rules, and what do these powers give? They give two very, very clear additional powers. The first is to reroute traffic and to do it on a class of persons which is undefined. So it's a wider power. You can intercept now a class of persons. Under the telegraph rules, even amended in 419A in 2014, you can only do it for a class of messages. So in fact, the level of surveillance is much broader. The second thing is you can issue directions to break encryption. Okay, this was not a specific power under the 419A rules. So in a sense, this is new. This is a step forward. And it's also important to remember that the notification has come after the right to privacy judgment. There is no examination of the proportionality. Now I'll quickly go to the second one. The draft process right now to change the exemption for online platforms such as Facebook and Google for end user content which is made available by us. Now, you know, the comments which are not coming in right now are with respect to the proactive censorship requirements, which Mr. Malviya has not even touched. So for instance, there is now the requirement mooted for proactive censorship by these platforms by using what is called technological measures, which may be artificial intelligence, to basically clean their platform, thereby making them as judges without any kind of legal standard, without any kind of process in place. And this is cutting against the 66A Shreya Sangal judgment, which held that state, which is government, such as the judiciary or police departments, need to give specific notices for content takedowns.
Okay, now, we'll come to it point by point. I want to also break it down so that you know, those who are watching this can understand what is going on and just move away a bit from the technical jargon. And I'll come to you for a bit of help with that, Nikhil. So explain to me what the concerns are. Say I'm an average user. Anyone who's watching this who is an average user, what are the concerns you have? Is it that anything that I tweet, message, type, post, etc. now can be seen by government agencies? Could they not see it before? Is it now that all of these online platforms will make it a point to come and see what I'm saying, and what are the parameters they will use to decide whether what I'm putting out is unlawful or not, or should be pulled out or not?
So look, Tamanna, I think one of the things to keep in mind regarding at least the intermediary liability rules changes is the fact that platforms will now be required to proactively monitor messages and content, and in effect, they will be held responsible for taking down messages that we may be sending to each other in an automated manner, if they feel that something is unlawful, or if their algorithms determine that something is unlawful about it. So you could be joking with someone about something in a private chat, but that message might never go through because the platform will sense that this might be unlawful. The platforms are in no position to judge this. But I want to go back into history about why these intermediary liability protections came into place in the first instance. Avnish Bajaj was the founder of a site called Bazi.com, and someone on his site was selling a pornographic clip. Now, he had no actual knowledge of the fact that this clip was being sold, and he was arrested by the Delhi police. If every single platform is held liable for the content that users are sending to each other, or is held liable for something that's being put up for sale without their knowledge, they will not be able to survive that liability. So most of these platforms will effectively fizzle out, die, because of the potential threat of cases that might come in. The intermediate liability rules also says that the amendments that are being brought in also say that any platform with more than 5 million users will have to have an entity in India, will have to have a grievance officer in India. This is practically unenforceable because so many new sites that come up, new platforms that come up.
No, so you're making an interesting point about what happens to smaller platforms and businesses. But I want to focus on the end user concerns. I want to focus on the end user concerns for a bit.
As an end user, Tamanna, as an end user, I am likely to be censored by the platforms without them actually having grounds to censor.
Okay.
And secondly, in terms of the surveillance, these agencies can effectively track all of my messaging, and I will never even know about it. So, we won't trust into an encryption brings trust into the system that what I'm sending to you personally is not being read by anyone. This is basically the government agencies will have a free run to read whatever they want.
Okay, Amit,
the government agencies are also one last point, Tamanna.
Yeah, okay.
Government agencies are also not accountable to anyone but the government itself. You can't expect them to act against themselves. There needs to be greater transparency from the government, and we need to be able to go to court. I have no doubt that both of these changes can and should be challenged in court, and they will lose.
That's a different story. Amit, I want to come to you with two specific questions. You say that the surveillance order is just a continuation of what happened in the past in the previous government. That by itself, I don't know if that's the best argument, Amit, because you don't want to necessarily perpetuate something which was done incorrectly in the past. And what you decide to do now, remember, this is a policy issue more than whether it's a BJP government or an NDA government, because what you decide to do now could be used/misused by future governments as well. What is the guarantee that all of these new changes, proposed and actual, will not empower political parties and governments of the future to censor, snoop, and force people to think about what they're writing and saying?
Okay, Tamanna, there are a couple of points, and I want to take them one by one. First of all, a lot of privacy activists created a lot of din around the Aadhaar, and the Aadhaar eventually, when it was put through the judicial scrutiny, came up with flying colors. So I take the criticism and the cynicism of so-called privacy activists with a pinch of salt. And I think we need to, at some point in time, learn to calibrate and be justified in our criticism. And that is a very, very important point I want to make here. Point number two, as far as any governments are concerned, whether it is our government or governments all over the world, every government has some or other mechanism to allow it to intercept, to allow it to decrypt conversations, because many a times this is required in national security, in terms of drugs, smuggling, unlawful activities, and a whole host of things. Therefore, every government would have this legislation. What any responsible government should do is ensure that it is moderated, it is balanced, and it is laid out, it is specified. Like the previous legislation, the 2009 amendment that I spoke to about was silent about who could do it. So technically anybody could use that particular provision in law and go ahead and snoop on your call, intercept it, and you will not have a recourse. At least now that is not the case. The third very important point about social media. Look, every platform, whether it's Facebook, whether it's Twitter, whether it's WhatsApp, or several other platforms that are being used today by people, have certain user policies, have certain community guidelines. If you violate that, they have the right to take you off. They anyway have all your record. Today, if you even go and type and search for something in Google, Google gets a volume of your data, and they have admitted to having that data in several of their dispositions to the US state and so on and so forth, the US Congress for that matter. And that is true for Facebook, that is also true for other things, because people voluntarily give that information.
This is different.
What we need to emphasize on is whether the information that people are giving is with their consent and with their knowledge. That is the kind of transparency that we need to be able to bring.
So I saw some of those amendments. You're saying you will stick these new rules inside the privacy policy, which most users do not read the voluminous pages of it, and this is a contract between the user and the platform. Here the government is trying to intervene and push in all of their own clauses and conditions. It's different, Amit. It's not the same thing.
Can I please finish what I had to say? I was just coming to that. What this amendment, or what the government is mulling, would allow it to do is to seek and ask these platforms to give it information in case it thinks that there is something which is grossly unlawful or illegal that is happening. And unless there is a law or a provision, some of these people who are operating in our country under our legal framework might not be obliged to do that. And therefore, to facilitate that, you do need these amendments. Now, let me give you a small example. If there is recruitment drive which is going on by, say, ISIS using social media, the government must have a provision, a law under which it can seek information about a particular operator who's either operating under or his or her own name or under a proxy name. And that is what this law will enable. I quite disagree with the example that the gentleman who spoke before me gave with respect to pornography, because pornography is dealt with under very different laws, and there are several other provisions that cater to it. But without this being a liability on the platform, it must make it obligatory for the platform to share information if it is sought. Today, there are technological advances to the point where governments, without having legal provisions, can't even get any of this information. And that is the situation which could potentially be dangerous tomorrow, and we want to avoid that.
Okay, Nikhil, do you want to respond to that and answer the counter? What's the alternative? What's the alternative if governments do need to have information and there's enough technology out there to mask it?
Well, there is technology out there to mask it, and there's technology out there to unmask it. I'm not saying that platforms, in case of legitimate court orders asking for legitimate information, should not give that information. And there are ways of providing this information where they have removed, for specific complaints, removed end-to-end encryption, but it's a mass surveillance that we're concerned about. To Mr. Malviya's point, I think it's necessary to first have surveillance reform. We need reforms over our surveillance agencies, over our intelligence agencies. We need them to be governed by Parliament first, before you start giving them more powers, right? And this is essentially enabling mass surveillance in the country. Secondly, on the point of intermediary liability, I just want to say, when there's one point which Apar also made earlier that keeps getting missed out, is the proactive monitoring and removal of content. And let's not forget that it was Kapil Sibal earlier in 2011 who had asked for pre-censorship of content. This is exactly the same thing. So the BJP is just doing what Kapil Sibal wanted to do then. There was a pushback then. They need to not do this now. It's easy to take a few cases here and there and use those exceptions to create rules for everyone for censoring a lot of content and for monitoring everyone.
Before I come to you, let Amit come in.
One last point.
One
last point. I want to make one important point, please, Tamanna.
Okay.
The purpose of Section 79 of the IT Act was not to enable surveillance, not to enable censorship, but to provide a safe harbor to intermediaries, to platforms, to allow them to function without liability. if they want to bring more provisions to govern them, they need to do it separately, not use a clause in the law that is meant to protect them to actually Amit, go after them.
Before I come to Apar, I want to come to Amit on the point that both Apar and Nikhil have been made about this proactive sort of ferreting out of unlawful content. Who will define what is the unlawful content? What is the extent of this ferreting out? And you've not answered my basic question, Amit, that how will you guarantee that these are not misused? People are afraid. You know, there is a journalist today who has been imprisoned for a Facebook post he made criticizing the government of the state he's in. These things frighten people. You'll have to make sure that these amendments don't end up censoring people or giving people a sense of fear.
You know, Tamanna, what's happening right now in the name of privacy is the worst kind of fear-mongering that we can see. I have only two limited points to make. One, that if there is a law and if there is clarity around the law, then the chances of its misuse are minimal. And people who feel victimized have a recourse in the judiciary. Today, that remit is not defined, and that is a scary proposition. We are moving towards a more rule-based society, and I don't know why privacy activists should have a problem with that. Number two, I also disagree and disapprove of this obfuscation by saying that what the UPA was doing is exactly what the BJP is doing. No, we are not doing that. We are not even for a minute suggesting that there will be any pre-censorship. The law or the amendment will only allow the agencies to ask for information, and it will be obligatory on the part of the platforms to give that information. Should there be a situation where people feel aggrieved about a certain violation, then they can always go to the court, and there will be a law under which they will be tested.
One sec, Nikhil.
And that is a very, very important fundamental point that most people seem to be missing. And third and last point I want to make, Tamanna, is that the volume of information out there is absolutely mind-boggling. And no government, no agency can put everybody on surveillance. Let's get this right, because the amount of data that is flowing out there is impossible to be tracked completely. Therefore, it will only be use-based, it will have to be justified, and it will have to go through a proper channel.
We'll need to have much more information then. Okay, let Apar come in. Okay, I want to hear from Apar now. I want to hear from Apar for a minute. Yes, Apar.
The first thing is there's so much hullabaloo being made about privacy activists. We actually won the Aadhaar case. There's a new requirement in which a judicial sign-off and warrant is required by a High Court judge before information can be shared of the Aadhaar database with any investigatory agency. This is as per Justice Sikri's judgment. The amount of time the metadata is stored has to be limited, and it cannot be linked to banks and mobile operators. In effect, what was being stated and the abuses of Aadhaar to a large degree have been checked. And this is post Puttaswamy judgment. The post the 2017 August judgment where the fundamental, please let me say it now, okay, has been restated. So you need to keep that in mind. The second thing is there is a proactive policing requirement by intermediaries by automated tools. This will result in a large form of censorship which will just scrub off entire bits of information under the threat of their prosecution. And the third and the final point is this is way worse than 2011. This is both surveillance and censorship. This is a Chinese model in which you're threatening.
Apar, give me the alternative. Give me the alternative. What is the alternative? You recognize that there is a requirement to know who and what kinds of people are sending out venomous messages which lead to killing of people? You agree that there is a requirement. What's the alternative?
Yes, that is the requirement, but it has to be channelized through a judicial warrant. Are they doing that?
How will you know who said?
If they don't do that,
you will first have to track where the messages are originating from.
No, you would have to demonstrate probable cause in front of a judge that you want this information. You just can't go and you just can't make that request directly. That's the new mandate even under the Aadhaar judgment. So you need to follow process. We are actually saying that The power of surveillance of the state by itself is not disputed. We are saying it needs to follow a process and a procedure. This is in line with the Justice A.P. Shah Committee recommendations in 2011 by the Planning Commission. So we are not against by itself the power of surveillance when it's individualized, but are actually wanting for safeguards.
Okay. Nikhil, just last word from me. Before you, I'll come to Amit because I know he has to run. Amit, the government will have to assure people that these rules will not be misused and it will have to be opened to a wider audience to debate.
Two quick points, Tamanna. One, that the gentleman who spoke before me spoke about Aadhaar and how the Supreme Court verdict has limited it. Let me tell you what the Supreme Court has said in particular about Aadhaar and link it with mobile phones and banking accounts. It has said that they must be regulated by law. What it means is that if there's an amendment to the Telegraph Act or there's an amendment to the Banking Provision Act, then those can be linked. The Supreme Court has not said that you can't do it. It has said that you have to do it and define it under law, and perhaps the government might do that as it is mulling options to do that. The second point on the concerns that you have raised, the entire amendment, by specifying that these are the only agencies who can do it, by specifying that platforms will be answerable to agencies when they are asked questions, essentially protects a vast majority of people who are using it for their own individual gratification or benefit and not the ones who are looking to misuse it. And third and the last point, I just kept hearing somebody say that you should first go to a judicial magistrate or somebody and then ask for permission to do it. I want to ask a simple question. If you want to find out if an ISIS operator is recruiting young men here in this country, would you go to a judicial magistrate, seek that information, give it all the publicity and then go and encrypt it? How is it going to help national security for that matter, or even drug smuggling or any unlawful activity?
Nikhil is most
mindful of what we think is practically possible.
Nikhil is most amused by your example.
These are very complex situations that we are trying to address, and you can't have very simplistic solutions which sound very good, which target the heart but really are of no consequence at the end of the day.
Nor can you turn this into a police state. So both facts remain. Nikhil, you were highly amused by that ISIS example. I want to ask you the same question I asked Apar Gupta.
You would ever allow it to be turned to a police state?
Let's hope not. But Nikhil, the same question I asked Apar. What is the alternative then?
Well, Tamanna, the alternative is that look, we need to have powers given to the state to protect us as citizens, and there's no one who's doubting that. There needs to be targeted surveillance that happens when there is proper judicial approval. If you believe that someone is a recruiter for ISIS, what is wrong with, you're not giving it publicity by going to a magistrate. It's not getting publicized as such. You're getting judicial approval for it. I don't understand why is a government that feels that there is probable cause, that it has a reason to go and snoop on someone, why is it afraid to go to the judiciary? Because it's afraid that it will get shut down. Look, you need protections. Citizens need protection from the state as well. Our constitution limits the powers of the state. The state is always trying to expand its powers. This is what this government has done. It's expanding its powers of both surveillance and censorship. And as citizens, all of us need to push back against it. This
is a very crucial debate which is going to play out in the next few days. Thank you so much to all of you for joining us in on this conversation, because I think we need to have more conversations like this. Just one thing at the end of it, whatever finally happens as a government policy, and it's not going to be restricted to just one government, it needs to go through a wider process of consultation. It can't be one person or one group of people deciding how all of India will live their lives and to what extent we will all be surveyed. Thank you so much for joining the show today.